Hello everyone, welcome to BYJU'S Exam Prep. I'm Nivedita Raje and today we are going to discuss important judgments in the month of August 2022. So we shall be going to present and discussing some very important judgments that I deem are important from your exam point of view. Every law entrance that you might sit for, CLAT, ALET, etc. So these judgments do not just give you an idea of what is happening in your country, in the legal fraternity. They also give you an idea of what the laws are and how they are interpreted, and they give you an opinion, they give you a perspective, which is very helpful when it comes to an upcoming law graduate. So you need to have that confidence of knowledge, the fact that, oh, I already know stuff. So this kind of encouragement gives you, and these kinds of news give you a lot of confidence. You have a doubt in article 74. You have a doubt in article 74, right? So I gave you a homework and I forgot to create a quiz on it. Sorry, but we shall have a quiz on the powers of clemency of both president and the governor. I completely forgot that I had to, like, I made it. I really did. I'm not lying. You got admission in National University. Oh my God, congratulations, Shivanya. Which is it? Make a video on how to understand passages. Tanisha, okay, let me come back to it. Everybody congratulate Shivanya. She got into a national university. I am dying to know which one is it. So which one is it? Hello, hello. Okay, so Tanisha, we don't need a separate video on it. I'll tell you right now how to understand passages. See, I understand that legal. Are we talking about legal passages, or are we talking about passages in general now, like every section, English and mathematics and GK, or are you specifically referring? You got into NLS Bangalore. Oh my God! Congratulations! That's so amazing. Congratulations, I'm so happy for you. You got into the best law college of this country. So how did you do that? Any words, any pearls of wisdom for your fellow peers who are preparing? NLU Bangalore, I'm congratulations. God bless you. You have done a great job. I'm really proud of you, and I'm sure that you must be really enjoying it. Yes, the journey has finally come to an end and you're bearing the fruit for it. Amazing, Shivanya. Very nice, very nice. So your efforts bore a wonderful fruit, a very sweet and a wonderful fruit that is going to nourish your life forever. If you did self-study, Shivanya, your journey is something that is remarkable. I would definitely want to talk to you, like, without any help, without any guidance. If you have been able to get into this college, this is something that I guess everybody would like to know about. So why, yeah, thank you so much, Shivanya. So why don't you contact me on Instagram, and we can arrange a short session in which you can tell everybody about your journey, as how you prepared it on your own. How did you manage it on your own? So this is actually a milestone. So guys, this is also possible. I never said it was impossible. You also got into NLSIU. Oh my God, one after another. What is happening? This is so good. Rishabh, congratulations. Amazing. So Shivanya, I would request you. Thank you so much, sweetheart. Thank you so much. But I don't know how much I contributed to it, but you are the one who deserves an applause. Sorry. Congratulations. Yes. So I would request you to leave a text on my Insta handle, Earth to Raje. Let us talk about it. I would love to speak with you. I would love your views on self preparation into tier 1 colleges that can be so helpful for students who cannot afford cannot afford to uh, go for batches and coachings and materials, which costs a lot of money because CLAT in itself is an expensive. So this can be, that's amazing. That's amazing. Contact me on Earth to Raje. Leave me a text. And Rishabh, congratulations to you too, buddy. Amazing, amazing. That's wonderful. And I think the semester has already started, hasn't it? Like they call you guys a little soon, right? Because to get ahead in the system. Congratulations to anyone, everyone, sorry, not anyone. Congratulations to everyone. Shivanya, again, do leave a text on Instagram. I would want to speak with you. And everybody would want to speak with you. Everybody would want to know how you managed. How you managed to do it. Okay. Yes. Okay. Now coming to Tanisha's problem. Tanisha, if you're not able to understand the passages, there are two problems that you might be facing. First is language. The English might be confusing to you. And the second is focus. You might not be as focused. You might be facing attention issues and language issues. So why don't you try, reading the passage twice and thrice and do it slowly. Yes, that's what we are going to do, Priyanka. If fortunately if I get her text, if I'm able to arrange a session, I would make it available to everyone. She would talk to you live on the YouTube platform. She would tell you everything about her journey, her self preparation, her motivation. It's very, very difficult, so don't worry about it. She will tell you everything. Okay, she will tell you everything. I'll make sure of it. Of course, of course. I know how important this is. I mean, the child deserves to be on TV. So be it. She shall be. Right. So yes, Tanisha, you're facing language issues and you're facing attention issues. So instead of fretting or burdening or creating a problem or creating a fuss over understanding the passage at one go, why don't you try reading the passage and solving them without a time constraint? Try to read them slowly. Okay, try to understand the English. English is not as difficult. Okay, if you continuously keep on reading it, it becomes easier. But if you're not in touch, for example, if your medium is not English, or the spoken language is not English, like in schools they don't really focus on it, that's okay, that's absolutely fine. So it's only concentration, and I think it's more of concentration than language. I'm sure you can understand English because everybody's session on BYJU'S YouTube is in English. So if you're able to understand me, that means that you can understand the language. You're facing attention deficit problems. So there are ways to increase it. Why don't you read it slowly, like line by line, instead of you know instead of reading it continuously at one go, read it line by line, one word, singular, very slowly. That should help you. Okay, and keep a pencil with yourself, and while reading, move your pencil along with the statement or the line. Make sure that your concentration is completely on the tip of that pencil. As your pencil moves, your eyes would move, your brain would learn to focus on where your pencil is moving, and you'll be out of this attention problem. Okay, try this and let me know in a week or so. That should work. That's how I worked on my concentration skills. I also had a problem. Okay, so let's start important judgments of August 22. So actually a lot of interesting things happened in August, and there are so many interesting judgments that I am just so desperate to share with you all, because it contains a lot of information about a lot of things. So shall we begin? Yes, let's do it. Yes, ma'am, let's begin. Yes, I know. That's okay, Shiv. That's okay, Tanisha. Sweetheart, you don't have to cry. I'm here to help you. Okay, try this first and then let me know. It should work. Actually, it will work 100%. So the only thing is concentration. Sometimes you're not as focused And that is the reason why you read everything and you don't understand a word. So it's all about focus. Make sure that when you're reading a passage, do it without a time constraint, do it without taking it in a mock, do it from a book, right? Don't do it online until and unless you're completely ready. Oh, that is so sweet to pass now. I'm just starting. Just let me help this sweet child. So, yes. Try to keep your phone at least 15 arms distance. Not one arm, not two arms, 15 arms. Don't keep it in the same room. Okay, don't keep your phone in the same room. Try that. That should work. Okay. So yes, hate speech case which was lodged against Yogi Adityanath, who is the Chief Minister of Uttar Pradesh. Now, what is the background of it? The problem is that Mr. Yogi Adityanath may have said something, and the things that he said, the inflammatory or the, you know, what should I say? The things that he said were so rigorous and were so enraging that people alleged that his speech, his arguments were actually the reason for the riots that happened in Gorakhpur. Okay, now Gorakhpur riots is not a fresh case, it's a very old thing. You can read all about it on Google. In fact, you should do it. So he said something and allegedly that led to a riot. People said that. And based on that, a case was lodged against him. Right. Now on August 26th, which was day before yesterday, Supreme Court dismissed the appeal which challenged the Allahabad High Court judgment. So what was the Allahabad High Court? Ashi, can we discuss this in the end of the lecture? We shall do it in the end of the lecture. Just remind me towards the end and I will tell you. Okay? Yeah. So now what happened was that Allahabad High Court, there was a plea in the Allahabad High Court to allow for the sanction. Now what exactly is the sanction? I told you that these people in the government, I told you that they have an immunity. Everybody knows that they have an immunity. Well, what exactly the immunity is? The immunity doesn't mean that they're immune from committing a crime, they're immune from penalties. So if at all they commit a crime, if they commit rape or if they commit murder, it is not that the system won't punish them. The immunity doesn't say that. The thing is that, you know, whenever a crime is committed, there's a certain process that happens. FIR is lodged, then investigation happens. There is an investigating officer who creates a case file, and in that case file he decides whether or not a crime is committed, and if he thinks that a crime is committed, he files a charge sheet. Now this charge sheet is submitted before the court. After the court reads the charge sheet, the case is completely filed and the case starts for trial. So this is the original process of every criminal case is. Okay, after the charge sheet is filed, there is a whole lot of new procedure. For a warrant case, there is a different procedure. For a summons case, there is a different procedure. The court first, you know, instead of directly asking for the evidences, it doesn't happen like it does in the TV serials. It doesn't happen like that. The court first asks if the person pleads guilty or if a person wants to confess that he committed a crime. So all that happens. Prosecution is given an opportunity to present his allegations, his accusations. So there's an entire different process to it. Now this process is available for everybody in the country, or let's say for an ordinary civilian. So Code of Criminal Procedure is applicable on every citizen of India. One thing. Now these people, the government officials, the executives, the foreign diplomats, etc., they have an immunity, which means that this code will not apply to them. In simple terms, if they commit a crime, they will not be subject to the same ordinary process of FIR, charge sheet, trial, evidences, etc. No, they have a different process, and that process decides or holds them guilty or not guilty. The ordinary process of appearing in an ordinary criminal court, defending like a criminal, that doesn't happen to these officials. That's where the immunity functions. So there's a separate process of holding them guilty, and most of these processes are interdepartment, like they happen within the department. The the judiciary doesn't get involved directly. The inquiry is first done by the department itself. If they are satisfied that yes, there are significant charges, then the case moves over to the court, and that is also a different procedure. And that procedure is listed in the law that gives that department their power. For police, there's a police act. For every other department, there's a different act. So people in that department, if they commit a crime, there's a different process that punishes them. That is what the immunity does, right? Everybody understood? Any doubt whatsoever? Hurry up, hurry up. Any doubt whatsoever? No doubt? I'm assuming there is no doubt, right? Now, what happens if there are allegations against the chief minister of the state, right? So he is the elected head in a state. Section 196 comes into play. What does the section say? The section says, before we go into the case, the section 196 CRPC says that a court will not take cognizance. What is the meaning of cognizance? Cognizance is acknowledgement of the case or deciding to move forward in the case law. Please explain in Hindi also. Okay. So guys, I'm translating everything into Hindi. I'm not adding anything new. The same thing that I said in English is going to be translated in Hindi. Nothing new. So my dear students who do not understand Hindi, don't worry. I've already said everything that I'm going to say now. Now Rakesh, ये आपके लिए है. मैं ये कह रही थी कि गवर्नमेंट के जो ऑफिशियल्स होते हैं उनके पास एक सर्टेन इम्यूनिटी होती है जो आपने अक्सर पढ़ी होगी. एग्जीक्यूटिव्स के पास इम्यूनिटी है, गवर्नर, प्रेसिडेंट, फॉरेन डिप्लोमेट्स, पार्लियामेंट के मेंबर्स, सबके पास एक इम्यूनिटी है. अब ये इम्यूनिटी करती क्या है? क्या इसका ये मतलब है कि अगर ये लोग कोई क्राइम कर देते हैं तो इन्हें सजा नहीं मिलेगी? नहीं, इस इम्यूनिटी का मतलब ये नहीं होता. इम्यूनिटी का मतलब है कि अगर ये लोग कोई क्राइम कमिट कर देते हैं तो इनको वही प्रोसेस से सब्जेक्ट नहीं करवाया जाएगा जो एक ऑर्डिनरी सिटीजन पे लगता है. जैसे अगर एक ऑर्डिनरी सिटीजन, लेट्स से अगर कोई क्राइम करता है तो उसके खिलाफ एफआईआर की जाएगी. उस एफआईआर के बाद इन्वेस्टिगेशंस, इंटेरोगेशंस शुरू होंगे. इन्वेस्टिगेशंस को करने वाला एक ऑफिसर होगा जिसको आईओ या फिर इन्वेस्टिगेटिंग ऑफिसर कहते हैं. वो आईओ एक चार्जशीट बनाएगा. उस चार्जशीट तब बनती है जब आईओ सेटिस्फाइड हो जाता है कि हाँ भाई क्राइम हुआ था और इन लोगों पे शक है हमें. इन्वेस्टिगेशन के बाद, एविडेंसेस को कलेक्ट करने के बाद ये निकल कर आया कि ये लोग इन्वॉल्व हो सकते हैं और आगे बढ़े केस, राइट? तो इस तरह से केस आगे बढ़ता है. फिर ये चार्जशीट कोर्ट में फाइल हो जाती है और फिर शुरू होता है असली कहानी, जिसे हम ट्रायल कहते हैं. ये पूरी जो बहस होती है टीवी में, माय लॉर्ड, तारीख पे तारीख और वो, ये सब कुछ चार्जशीट के बाद होता है. अब इम्यूनिटी का मतलब ये नहीं है कि इन लोगों को सजा नहीं मिलती. इम्यूनिटी का मतलब है कि इन लोगों पे ये प्रोसेस नहीं लगता. अगर इनको सजा देनी है या फिर उन्होंने कुछ किया है तो इनको सजा देने का एक अलग तरीका होगा. जनरली इनके लिए डिपार्टमेंट में ही कोई कमिटी या कुछ ऐसा पैनल बना दिया जाता है जो इनकी गिल्ट को डिटरमाइन करता है, जो ये पता लगाता है या इन्वेस्टिगेट करता है कि भाई इन लोगों ने वाकई कुछ गलत काम किया. जैसे अगर एक पुलिस ऑफिसर ने एनकाउंटर कर दिया है तो उस पर मर्डर की एफआईआर नहीं लगाई जाएगी. पुलिस डिपार्टमेंट अपने आप में ही पहले इन्वेस्टिगेट करेगा एक न्यूट्रल पैनल को फॉर्म करके कि वाकई एनकाउंटर रियल था या फॉल्स था या फेक था. उसके बाद अगर वो सेटिस्फाइड हो जाते हैं कि एनकाउंटर फेक था, तब उसके बाद का कुछ और प्रोसेस होगा. लेकिन अगेन वो प्रोसेस कोड ऑफ क्रिमिनल प्रोसीजर में नहीं होगा. वो प्रोसेस उनके अपने एक्ट में होता है जिसे हम इंडियन पुलिस एक्ट कहते हैं, और हर डिपार्टमेंट के साथ यही चलता है और यही इस इम्यूनिटी का काम है। ये सिटीजन्स ऑर्डिनरी नहीं है, ये गवर्नेंस का पार्ट है, लॉ एंड ऑर्डर का पार्ट है, एग्जीक्यूटिव का पार्ट है, तो इनको ऑर्डिनरी प्रोसेस से सब्जेक्ट किया भी नहीं जाता, क्योंकि अगर इनको कोर्ट में तुम लेकर आ जाओगे तो लोगों का जो भरोसा है अपने लीडर्स पर, अपनी गवर्नमेंट पर, वो टूटने लगेगा कि भाई हमें प्रोटेक्ट करने वाले ऐसे लोग हैं जो फेक एनकाउंटर कर डालते हैं, या हमें प्रोटेक्ट करने वाले ऐसे लोग हैं, हमें गवर्न करने वाले ऐसे लोग हैं जो खुद रेपिस्ट्स और मर्डरर्स हैं। अगर ये सारी चीजें कोर्ट में आने लगेंगी तो मीडिया इसका क्या बखेड़ा बना देगा, और फिर बहुत ही मुश्किल हो जाएगा गवर्नेंस की स्टेबिलिटी को मेंटेन करना, और इसलिए इनको सब्जेक्ट ही डिफरेंट प्रोसेस से किया जाता है। समझ आ गया? एवरीबडी क्लियर? Okay, so I said everything in Hindi, same thing, right? So how does this happen? How does a chief minister, okay, or anybody in the similar wing or a part of the government gets punished? So section 196 says that a court shall not take cognizance. What is cognizance? Cognizance is acknowledgement of a case, that yes, we are moving ahead. It is not a decision to go ahead with the case, it's just the acknowledgement that we are moving ahead, more like that. Okay, so a court does not take cognizance of any offense which is punishable under section 153A of the Indian Penal Code, or section 295A, or subsection of 505 of the Indian Penal Code, or a criminal conspiracy to commit such offense, or any abetment as is described in section 100A of the Indian Penal Code, except with the previous sanction of the central government or of the state government. Now there are certain offenses which cannot be complained of just like that. So your homework for today is, write that down guys, your homework is to read section 153A and section 295A. I know Krishna, but we are under an obligation to speak in English. You don't have to remember any sections. No, not at all. Don't worry about it. These are just for your knowledge. Okay. So your homework is to read section 153 of the Indian Penal Code and section 295A of the Indian Penal Code. Now, if there is a case against 153A and 295A, or if there is a criminal conspiracy to commit any offense under these sections, or if there is any abetment in section 108A of the Indian Penal Code, again, yes, this is also your homework. So if an offense is committed under these sections, these three sections, or if there is a criminal conspiracy done against these sections, or if anybody is abetting these offenses, so there are three situations. If any offense is actually committed, like this offense under the section is actually committed, or there was a conspiracy that this offense will be committed, we will get together to commit this offense, conspiracy like that, or abetment. Everybody understands what abetment is. Abetment is instigation to commit a crime. When instead of doing the crime yourself, you make somebody else do it. Instead of making your own hands dirty, you make somebody else do the dirty work for you. That is abetment in short. Okay. So if there is a criminal conspiracy for these offenses or abetment to commit these offenses, a complaint or court will not move ahead with the charge sheet unless and until central government or state government has given a permission to do so. So if you want the court to go ahead or to move forward with the trial of these cases, you need to obtain previous permission from the central government or the state government. Now your homework, you've got 4 homeworks now. Your homework is to find out which section was imposed or which section was invoked. It's act number 45 of 1860. That's not important. Okay, actually the Indian Penal Code was amended. It is not 1860 anymore, if you know. Ashi, again, let me complete the session, then we shall discuss it. अभी मैंने कहा था. Okay, so yes. Now, which section was invoked when the complaint was lodged against Yogi Adityanath? First, okay, what are these sections? Section 153A, 295A and 108A. फिर से बता देती हूँ मैं, योगी आदित्यनाथ के ऊपर इन तीनों में से किस सेक्शन को लगाया गया है, ठीक है, कौन सा सेक्शन लगाया गया है. नाउ, और ये तीनों सेक्शन में क्या है ये भी आपको पढ़ना है, तो ये आपका होमवर्क है. डू इट, डोंट फॉरगेट इट. ओके, this gives you a good reading practice and also improves your research skills. That is why I give you this homework, because I can definitely tell you, but I don't want to spoon feed everything. So if you make an effort of your own, you'll get to learn a lot of other things also, which is a good thing, right? That's how you prepare. Now, Yogi Adityanath has committed an offense allegedly in one of these sections. So if you want to punish him, you need to take a sanction from the state government or the central government. Now, the problem was that when the sanction was applied for, the state government denied it. It refused to give any permission for the court to take cognizance or to move ahead with the complaint. Now, this denial by the state government was challenged in the Allahabad High Court. Okay, and Allahabad High Court upheld that this denial is right in the situation or in a circumstance where the speech was made. It is not inflammatory, it is not related to the riots that happened, and a complaint against Yogi Adityanath in that section is not significant or is baseless. That is why the denial of sanction in this situation is valid, and based on this the denial was upheld. Now, Allahabad High Court judgment was again challenged in the Supreme Court, and the Supreme Court said the same thing. The Supreme Court dismissed the plea and upheld what Allahabad High Court said. It said that Yogi Adityanath's speech was not inflammatory, it did not lead to the riots, there is no evidence to support that argument, and hence the denial is completely valid. Do you understand, everyone? Good. Okay, now these are the sections. 153B. No court shall take cognizance of any offence punishable under this section or subsection 3 of 505 of the Indian Penal Code of 1860, or any criminal conspiracy to commit the offence except with the previous sanction of the state government, central government, or DM, district magistrate, who is also known as the executive magistrate. Now, case number 2, freebie case. What exactly is our freebies? Now, everybody is aware of this pre-election process, right? When the campaigns are going on. Now, what happens in these campaigns? People are in, those roofless cars or autos, or what? Oh, you have a doubt? Okay, what is it? Let's solve that before I move forward. What is it, Sanjana? I'm waiting. Okay, while Sanjana posts her doubt, let's move forward. Now, what happens is, so you must have seen everywhere. Can you tell me what is the difference between 230, 23B and 23A, etc.? What? Of what? 23B, 23A of what? Of this Where is 23A and 23B? A 23B of IPC section. There is no 23A and B of IPC. What is A B difference? The multiple clauses. A and B, they're just clauses. Okay, so instead of increasing the number of sections, they just add clause to it. That's it. That's the difference. There's nothing complicated about it. So if there is a section, for example, if there is 196, section number 196, and it says a certain thing, but you need to say it in different manners, like, you need to incorporate this section also, there is an exception, there's that and that. So you just add clauses to it instead of recreating another section, right? So you make that section exhaustive, sort of. So that is the purpose of these clauses. That's it. No, nothing complicated. Okay, now freebies. So I've often seen these people, especially in television. Like, I haven't seen a live campaign, but you must have seen back when it was, okay to advertise it. I still remember when Lal Krishna Advani was, campaigning for himself, and it was proposed that he would become the chief minister, but then he didn't. That's okay if you don't understand the difference. There is no need. You will eventually, but I'll tell you later on. Okay, not right now. Now, so back when Lal Krishna Advani was sitting for the, like, BJP was campaigning, and he was the announced leader of BJP, so he would have become the prime minister if Congress hadn't won. So I remember that he advertised that if he wins the election, the wheat would become 2 rupees per kg. For some reason, it is still in my head. So the wheat is a staple. Gehu is the staple for every region in India, like most of the regions. So roti is like a staple, right? So wheat would become at 2 rupees per kg, which is accessible to everyone in the country. Nobody would die of hunger. Everybody can access grains and atta and everything. Okay, even people below poverty line. So a kg is quite a lot. So if you can manage 10 bucks, you can get a lot of atta, and you can, arrange food. But BJP didn't win. Now, the promises that people or these uh, candidates make during their campaigns are called freebies. Okay, now these freebies are done or promised by every political party. It is not that there is a certain person in a particular party who is promising certain freebies, or I'll do this, I'll do that. Everybody does it. Everybody. Okay. Now, if these freebies are in terms of, now these freebies are not just commodities, just so you know. The freebies are everything that is promised. Okay, so if they are, promising a certain change in the tax regime, or if they're promise a certain relief in certain policy, or anything, is it? So freebies are not just commodities or promise of commodities that will give you clothes and houses and everything. It is everything that is promised by a political party which is doing its electoral campaign, right? Now the problem is that sometimes the, candidates in these political parties become a little too ambitious, and in that zeal, in that over enthusiasm, they sometimes promise irrational freebies. They make irrational, unachievable, a little too ambitious promises, which take a toll if they become the leaders. Now the problem is that if they actually get elected, if the party does win, the burden to fulfill the promises land on the state. Now, if you have promised a lot of things, you have to deliver at least 10-15% of it. That is what the agenda is. So they never target 100% delivery, but they make sure that 5, 10, 15% is at least delivered, so that they can save something for the next election, that we were doing this and we are in the process and we promised to finish this, right? So they never complete a project, so they have something to promise again in the next. Yes, yes, of course, free electricity is a freebie. Like I said, everything is a freebie. Every promise made by the political party that they, yes, they're also counted as freebies. Yep, they're counted as freebies. Now, there was this very, very important thing that NV Ramanna noticed right before the day of his retirement, and it was very thoughtful, and it was something that should have been highlighted years ago. Now, NV Ramanna said that the Solicitor General, Election Commission, and the other parties say that whatever freebies or whatever promises that are made to secure votes is actually a way to increase the popularity, so that people, get influenced, get greedy. The world is greedy in a third world country where people are starving and they're, struggling for necessities, for basic necessities. They, if they get even a little bit of an idea that yes, if I, make him my leader, he might give me a house or might give me a job, that's enough for them. That's all they want from the leaders. So that creates an unsolicited burden on the taxpayer. So people who are paying taxes, now how do you think these government parties or the political parties work? How do you think the governance in the entire country runs? The governance is run through the taxpayers' money. We pay taxes, and that's how the country is run. Now, if you promise something irrational, you need to deliver a certain quantity of it, and that certain quantity would take a toll on the taxpayers' money, which is not fair. So, announcements like these can lead to a situation where the state is not able to deliver what it wanted to. So, do not promise anything, even if it is a necessary facility, until and unless you have the resources, you are confirmed that you would be able to deliver it after coming into power. So before a promise or a brochure is created for an electoral campaign, it has to be examined from every angle, from every parameter. What are the funds that the central government uh, gives to you? What leeway do you have to give whatever it is that you want? Sorry, to the citizens of India or to the citizens of your state. Now, everything is to be done. You cannot just promise people something and then create an unnecessary burden on the resources of the state. Do not promise anything, first of all. If you are promising something, make sure that it is deliverable, so that people are not manipulated by false promises. So, that is what they're considering. In fact, there is a talk of incorporating a rule against irrational freebies and irrational promises also. So if there is a political agenda wherein the brochure has something which is unachievable, too ambitious, and does sound like manipulation, the brochure would be cancelled and the nomination of that candidate might also be cancelled. Now this is only a talk, it is not done yet. They're only discussing something like that, and if they do, a lot of manipulation can be controlled. A lot of manipulation can be controlled. And if these, candidates do not get an opportunity to manipulate for votes, people in India can actually decide with a rational mind, with a neutral point of view, who can be their leader. Okay, they can overlook the promises because they aren't there, and they can uh, decide on the basis of their background, their capabilities, and their academics, everything that they own and they come from, and based on that they can decide whether that person would become a good leader or not, if the manipulation is removed from the equation. So these announcements, etc., there might be a situation of an amendment where in the, in the rules of electoral campaigns, it might be completely removed altogether. Like, you cannot make irrational, or you cannot make any promise. You cannot just promise people something and manipulate them into giving you votes, you can do it. So let's say what happens, this is a very, it's, I decided to incorporate this because it, even though it is just an observation, if it does get formulated into a law, it will change the entire structure of our democracy, which is a very necessary step, especially in this time where the country is going crazy on the communal lines. So this is something which needs to be done. Free education, free health, of course, a third world country like India cannot afford free education and free healthcare right now. The economy is not as sufficient. The investment over the investment of, maintaining the defense forces, a standing army, arms and ammunitions, all those activities is too much, and that does not allow us to make our healthcare and education free. The countries which have done it have nothing that they can call as defense. Switzerland, Sweden, they don't have armies, they don't have defense. The A major chunk of their revenue goes into providing free education and free healthcare to their citizens. Why? Because they don't have to invest on other things like defense forces, maintaining an army, acquiring missiles, acquiring robots and tanks and air forces, oh sorry, airplanes and this and that. Do you think they're cheap? They're incredibly expensive. So that is why they're able to give it. A third world country like India, if promises free healthcare and free education, that is an unachievable thing. Even if they want it, they cannot do it. In a crumbling economy, the world is crumbling in terms of economy. India cannot do it. It is unaffordable. They'll go bankrupt within few months. Okay. So yes, that is what the freebie case is. I think you understood the reason why I adopted it. Okay. So the Supreme Court refers election freebies case to a three-judge bench. Now this three-judge bench will decide whether the freebies are allowed or not. So I'm really excited for this case, and when the judgment comes, you'd obviously know about it, right? Now we have the Pegasus case. What exactly is the Pegasus case? Everybody knows what Pegasus was. Pegasus was an Israeli spyware that was, found somewhere around what? I forgot the year. Yes, it was developed in 2010. Now what happened was, it was kind of a malware. Okay, yeah. So it was kind of a malware which was sent to people's phones or computers through texts, emails, and unsecured links. So if people open the links given in the texts or emails or any mode of communication, the link would direct them to a certain page which has a lot of virus, and this Pegasus spyware would creep into their phone and hack it. Now this Pegasus could hack into the phone without the owner even realizing it. So you could access your phone, work on it, and you wouldn't have even a slight idea that you are being followed, or everything that you do on your phone is can actually be seen by somebody else too. So this is what Pegasus could do. Now Pegasus was extremely dangerous. It could hack into the security and the confidential channels of any economy, which could have been fatal, right? Very, very dangerous. So the Supreme Court, in order to protect the right to privacy given in the case of Puttuswamy versus Union of India, in which it was declared that right to privacy is not an ordinary right, it is a fundamental right which is guaranteed under Article 21. Now, if you are giving such significance to a right, you need to make sure that that right is protected. Now, Pegasus, if is allowed undetected and unsolicited or uninvestigated, people would lose their privacy. Who is to say what is happening in my phone or in your phone? Or who is monitoring your phone, my phone? I was just talking to my mother about a certain dress, and suddenly the suggestions regarding the kind of dresses started coming on my Insta page. Now I am completely sure that my phone is hacked. But then I think, what would you do if you hack my phone? So, yep, that's why I really don't pay attention. Like if they have hacked my phone, there's nothing that they can found. I don't take pictures and anything. I don't really use my phone except to play games. So that is what happens. And there was a lot of evidence, like significant evidence, which proved that Pegasus spyware was found in at least 29 phones that was scanned by Pegasus panel. Now there were some other malwares also that were found in other phones, but there was nothing conclusive to show that it was Pegasus. And to finally figure out that Pegasus has crept its way in the Indian system or in the privacy of our lives, we need a committee to hold proper investigation to figure out where we hold on the Pegasus spyware cases, and do we have a system strong enough to combat the situation. This was the objective of the committee that was asked by the Supreme Court. So Supreme Court ordered that the government should form a committee, an investigative committee, to figure out whether Pegasus has really infiltrated our channels, and if it has, how do we come out of it? And if it hasn't, what do we do to prevent it from happening? So that was the work of the investigating agency. Turns out they didn't do anything. They didn't do anything. Okay, so the evidences were not clear, they were not as significant. The committee report was, full of mistakes and anomalies. There was no addition to the investigation, there was nothing significant done by the investigating committee, and that is what ticked the Supreme Court. Now, you know what all of this is. You have already read it. You have already understood it. Abhimanyu sir or Salik sir must have made you understand what Pegasus is and why does it pose a potential threat to our economy. Now, my question is, if the government does not follow the order of Supreme Court and starts working immediately on this issue, what do you think they would be committing? Can anybody tell me? I would be so impressed if you can, like really impressed. What do you think Supreme Court can charge them with? Although it is not mentioned in the case, Pegasus is a type of spy or software in phone. And ma'am, do we have to write down points given in PPT? Sanjana, it's completely your discretion, honey. If you want, you definitely can, right? But I would suggest that you write it down in your own words. Pegasus is not a human, it is a digital virus that hacks your phone. Very good, Harshita. I am so impressed. Harshita, everyone. Yes, it is contempt of court. Now, what kind? Civil or criminal? Civil or criminal? Not penalty. Harshita got it right. Harshita, I am expecting answer from you. What kind of contempt would that be? Yes, please tell me. It is very good. Yes, everybody has answered. Very good. Guys, that is so wonderful, you guys. I'm so happy that you are so clear with your concepts. Are you proud of yourself? Because I am. Okay, pat yourself on the back on my behalf, because I cannot do it. Digital world, right? So pat yourself as a symbol of me giving you appreciation. Good job, bravo. It is civil contempt. Yes. So if the Supreme Court or the High Court, okay, High Court and Supreme Court both are courts of record, which means that they can file or charge somebody of contempt. So if there is a direction given by any of the court, high or supreme, and the direction is not followed by anyone, be it a government agency, be it even the governor of the state, if that direction is not followed by any department, government or private, that would amount to civil contempt. Got it? So in this situation also, if the government does not follow what the Supreme Court has been asking them to do, they would be liable for civil contempt. Although the Supreme Court hasn't listed that yet, but generally that is the scenario. Okay, that is what happens. Got it? Now we have PMLA case. PMLA case is something that we have already discussed in a huge detail. Like there was an entire article on PMLA in the Hindu, and I think we did a legal analysis from top to bottom. Why is PMLA targeted and everything? So I'll give you a brief, and you can watch that session and get a better idea of what exactly PMLA is, right? So PMLA is Prevention of Money Laundering Act. Now there's a department, a very, very strong department, which we call ED. Okay. Now sometimes what happens is people earn through invalid or illegal sources. Now since they are making money illegally, they cannot report the money, which means that they have to hide that money. When that money is hidden, government does not have any accountability on it, which means that they do not pay tax on it. If they start accounting for that income, the IRS, not IRS in our country, the IRS would immediately get concerned as to where that much money is coming from. Now, if they track the sources, their crimes and illegal activities would come out in the light. So instead of reporting that money, they hide their money so as to hide their illegal activities, right? Now that money, since it is hidden, they don't have to pay tax on it. Now since they don't pay tax on it, it becomes black, which means it is not known by anyone. This black money is secured. Now if they start spending that money, obviously they would get noticed. If they deposit that much money in their bank accounts, the bank would notice. Like it is very difficult to spend or invest that much amount of cash. How do you spend that much cash? Now in order to convert black into white, there is a whole lot of channels, right? So what they do is they send the money or the cash somehow through hawala to international agencies or banks, which in the lieu of giving donations to their fraud or fake NGOs or companies, convert it into white. Now they take a certain fee and they convert the black into white. This process of converting black money into white money is called money laundering. Now why is money laundering dangerous? These agencies that convert the money from black to white, they charge. They don't do it for free. Okay, they charge a certain percentage on it depending on how much the amount is it. So this percentage is not again used for legal purposes. This percentage of money that they make is generally used to provide funding to non-state actors or terrorist organizations, which creates instability in the entire world. That is why money laundering is dangerous. Now, ED or Enforcement Directorate is in charge of making sure that money laundering is controlled or does not happen in India. Basically, to monitor the activities relating to black to white money, ED is responsible. Now, where does ED gets its powers from? What law or what institution gives the power to ED that they can check and arrest anyone who they think is doing money laundering? This act gives them the power. Prevention of Money Laundering. Okay. Now this Prevention of Money Laundering Act, there are certain sections in PMLA which were challenged in the Supreme Court, right? That on the grounds of violation of Article 14 and several other articles, like the constitutional validity of certain provisions in PMLA was challenged in the case of Vijay Madan Lal Chaudhary versus Union of India. Now, this is an important judgment. Okay, Vijay Madan Lal Chaudhary versus Union of India, and Supreme Court upheld the validity of the provisions of PMLA and gave a reason why they do not violate the constitution. Now, on the face of it, they do seem violative, like they actually go against the constitutional spirit. They sort of, seem to be violating Article 14, and they do seem to be violating the ordinary process of CRPC, FIR, etc. I'm blurred. That's okay. You can hear me properly, right? I think it's the audio that's more important. Is the audio clear? Everyone. The audio is not clear either. Is it? I understand I'm not visible, but I want to know if I'm audible. Audio is clear? Well, then let's move forward. Video will clarify itself. It's a little thing that keeps happening, like internet going up and down. So let's not worry about it. Yeah, so let's focus on the audio. As long as you can hear me, everything works, right? Yep. Now, so these provisions were challenged on the basis of constitutional validity. Now, the Supreme Court said that the provisions are constitutional. We understand that they are different, but there is a reason why they are different, right? And the reason was explained, and they were held to be not violative of the Constitution. Now, the judgment related to PMLA is discussed in my Hindu editorial analysis, which you should watch. In that analysis, I have discussed the provisions that were challenged and the reason that the Supreme Court gave to justify their constitutional validity. Okay, do watch it. Okay, yes. Now, what is PMLA Act? Let's do that. Prevention of Money Laundering was enacted to fight against the criminal offense of legalizing income or profits from an illegal source. Now, the PMLA enables the government or the public authority to confiscate the property earned from illegal proceeds. Now, the act was formulated to do the following. What? To prevent money laundering, to prevent channelizing of money into illegal activities, like I told you, economic crime, non-state actors, terrorist activities, etc. To provide confiscation of property derived from these illegal sources and money laundering, and to provide matters connected or incidental to the act of money laundering. So if there is any matter that the authorities think is anyway related to the money laundering act or any person who is doing the money laundering, they can investigate the person, direct proceedings against that person, right? So that is the case. Now again, to watch the case in detail, I would suggest you watch my session on the Hindu editorial analysis of PMLA. Do watch it. Now we have the final judgment of the session. Talaq-E-Hasan, not so improper. Prima facie, women have option of khula divorce. Now, whenever the problem of Islamic practices come into picture, these Muslim clergies, Maulanas, and various people, Ajitesh, from GK current affairs, it might be important. From a legal point of view, it is not. The laws involved in it are not for your subject, but from a factual point of view, you can read it. Like on the periphery, don't dive too deep in it. Okay. Yeah. Now, whenever a practice coming from Sharia is challenged. Now, this practice Talaq-E-Hasan is actually given in section 2 of Shariat Application Act of 1937. Okay, Muslim personal law. Now, whenever a Muslim or an Islamic practice is challenged, the clergy, Muslim, Islamic clergy, Maulanas, and everybody favoring these practices, the patriarchal society, everyone, they always say that in a country as secular as India, you cannot make these practices void or you cannot ban these practices. And if you are doing it, you're sort of imposing your own Hindu law on us. That is their argument and that is their attack. I'll explain. I'll explain. Don't worry. Right now, what they fail to miss is the challenge on these practices is not done by the government or a Hindu man sitting in the government. It is actually done by the Muslim women themselves. They're the people from their own religion that are against these practices. So, accusing the government or the people in the government of imposing Hindu laws and Hindu religion on the Muslims is unreasonable. Anyhow, coming to our case, what exactly is Talaq-E-Hasan? Now, I have explained to you what kind of talaqs are there. Talaq-e-Biddat is banned in India. Okay, Talaq-e-Biddat. Which case was it banned in? Talaq-e-Biddat was banned in which case? Can anybody tell me? Yes, people. What was the case name in which Talaq-e-Biddat was banned and it was made a punishable offense? Not just banned, it was made a crime. It was Shaira Bano versus Union of India, right? So in Shaira Bano versus Union of India, the practice of Talaq-e-Biddat or popularly known as very good Sakshi, very good. It is not Shah Bano Alfia, it is Shaira Bano. Okay, Shah Bano is a different case. It's on maintenance. It's Shaira Bano, yes. So, yeah. So, Talaq-e-Biddat or more commonly known as the practice of triple talaq, 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 or pronouncing talaq simultaneously one after another at one go is called Talaq-e-Biddat. Now, this practice was banned on grounds that it is violative of Article 14, 15, 19 and 25. Okay, so right to equality, right to freedom of expression and right to freedom of religion, all these articles or all these freedoms are violated if this practice is allowed to be continued. Now, based on this, the Supreme Court in Shaira Bano versus Union of India, yeah, banned the practice, and they not only banned the practice, they sort of made it punishable. The legislature immediately came into play and they passed an ordinance which made that practice a criminal offense. Later on, that ordinance was created into a full-fledged law, right? Now, this is Talaq-e-Biddat. What is Talaq-e-Hasan? Talaq-e-Hasan is an extrajudicial form of divorce. Now, the Sharia basically provides for different types of divorces or different modes in which divorces can be sought. So, there are judicial divorces and extrajudicial divorces. So, if by a customary practice laid down by their personal law, which is divided into Talaq-e-Hasan and E-Hasan, if they do it in their own family, like without going to the court, without seeking any lawyer's help, we call it extrajudicial divorce, which is allowed. Okay, which is allowed. Judicial divorce is just like any other divorce, which is sought through the help of judiciary. You file a notice, you seek the help of the court, that there are proceedings and there is a motion, and that's how the divorce is filed. So instead of going to the court, they sort of settle it among themselves. Okay. Now, Talaq-e-Hasan is a practice in which instead of calling out for talaq at one go, it happens over a period of time. So if a man wants to divorce his wife, he will say, he will file or he will send her a notice. He can either send her a notice or he can pronounce talaq. After he pronounces talaq, she goes on an iddat, okay, for 3 months. Now, if he during that iddat, after a period of 30 days or more, If the marriage is not consummated, which means that they have not reconciled, they are living separately, he says talaq again, that becomes the second pronouncement. Now, between the first and the second pronouncement, there has to be a minimum gap of more than 30 days. After second pronouncement, if again there is no reconciliation, the marriage does not get consummated, and after the second pronouncement and more than 30 days after the second pronouncement, if the husband says talaq for the third time, that talaq becomes irrevocable, and we call that practice Talaq-E-Hasan. Got it? Now, Talaq-E-Hasan, or the pronouncement of talaq in this practice, cannot be made during a woman's menstrual cycle. That is an essential. Got it? Everyone, do you understand? Now, the problem with this was that there was a lady who filed a case and filed a case of domestic violence against her husband's family. She alleged that her husband and his family domestically violate her, or domestically are violent towards her, and they demand unreasonable expensive gifts from her family, which puts a toll and a burden, and when the family is not succumbing to the demands, they beat her or get physically violent with her. Now, as she lodged a complaint, immediately after her complaint, her husband, since he cannot practice talaq-e-biddat anymore, he immediately pronounced talaq via practice of Talaq-E-Hasan. After the practice was made irrevocable, now he did it within a matter of 3 months. He did it once, then he did it. That's where we are. That's the question is. The entire case is based on that question, Himanshu. Why have we not banned Talaq-E-Hasan? It is also, violative and discriminatory. So that is what we are going to discuss. So the lady was given talaq by pronouncing Talaq-E-Hasan. Okay, pronouncement within, or once a month within 3 months. That is the pronouncement. Now, after she was given talaq by this practice, she challenged this practice in the Supreme Court. Now, there are other women who have challenged this practice in Delhi High Court also. Okay, so this was more than 2-3 months before. So the practice was challenged in Supreme Court again on the same basis that this practice is violative of Article 14, 15, 19 and 25, and it is as dangerous and discriminatory as talaq-e-biddat. The question is how? Now, let's say that there is a woman who is not succumbing to his husband or his husband's family's unreasonable demands. Now, if she is not surrendering to the demands, or if she is not listening to him, he can always threaten her with the fact that I will give you talaq. Now, this talaq is done over a course of time, which means that if a person says, I will give you talaq, मैं तुम्हें talaq देता हूँ, said and done once. Now she has a time to rectify her mistakes within 30 days. So if within 30 days and more she doesn't rectify, or she doesn't surrender to her husband or husband's family, he will say talaq again, which will give her more 30 days. If she doesn't surrender again, he will say talaq for the third time, and the talaq will become irrevocable. So this is more like giving a threat or a warning to the wife that बीवी सुधर जाओ नहीं तो तलाक दे दूंगा. So this is more like a threat, and it is not fair, and it is not fair as per the Constitution of India. That is what is said in the case which is filed in the Supreme Court. Got it? Now, again, another contention coming from the petitioner is that this gives an arbitrary or a whimsical right to a husband to divorce his wife if she does not listen to him, which is as bad as talaq-e-biddat. Like in talaq-e-biddat, the lady does not get a benefit of doubt. If she makes a mistake and the husband is in bad mood, he can just say talaq, 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 and the marriage dissolves. Whereas in Talaq-E-Hasan, the same thing happens, but it happens over a certain course of time. but it is a similar threat which creates an unwarranted burden in the head of the woman. No woman wants her marriage to get dissolved, and this is a very good way of making her do what she might not want to do, right? That is the problem. So that the same right, the same threat, or the same discretion or arbitrary right is not available to the woman, and that is why Talaq-E-Hasan should be banned. Now, Talaq-E-Hasan finds its validity not just from Sharia, it finds its validity from Dissolution of Muslim Marriage Act 1955 or 57, somewhere around it. So, Dissolution of Muslim Marriage Act actually, you know, declares these practices as valid. Talaq-E-Hasan is Talaq-E-Biddat only. Talaq, talaq, talaq. Okay. Yeah. So, Dissolution of Muslim Marriages Act sort of validates these practices, these customary practices. Now, the lady has not only sought ban on the practice, she has sought ban on Dissolution of Marriage Act per se, because it accounts for many practices that are not right. For example, even I'm completely forgetting the name. What is the practice that a woman has to observe after she gets divorced and she wants to marry the same ex-husband? No, it is not valid. And the name is slipping. I'm sort of getting confused. Can anybody tell me that practice where there's a certain practice that a woman has to observe if she wants to marry her ex-husband? Halala. Thank God. Yeah, so Dissolution of Muslim Marriage Act, it lists several practices which women find extremely discriminatory and arbitrary, including halala and everything. So she has thought that this act altogether should be removed. This is a stupid act which provides for bad practices, bad customs which are creating a lot of discrimination in the Islamic society between men and women, and this, no, that's halala. Yeah. So that law should be removed entirely altogether. Now, in this case, the Supreme Court observed that we understand that that men have, sort of arbitrary practices that they can observe when it comes to dissolving the marriage, and Islam gives them that benefit. But it is not that Islam is just giving a benefit for to the men only. Women have the similar right. So it is not just the men who can threaten the woman or obtain a decree of divorce through any practice. Talaq-e-Biddat is absolutely horrendous and we removed it. But Talaq-e-Hasan is not as unfair, considering the fact that Muslim women have similar rights. If they want their marriage to come to an end, they can get khula. So khula is the divorce filed by the woman. So if a woman wants to get her marriage cancelled, she can obtain khula. That is a practice or a right available only to women. Now, everything given by the women's father in the form of dahej, dowry, and the meher, hak meher, everything has to be returned to the women. So it is not that the men have the right to file for divorce in Islam. Women have equal rights. They also have an option of seeking divorce through different mechanisms, whether extrajudicial or judicial. So Talaq-e-Hasan, it doesn't seem as improper since women also have an option to file for divorce. And that is why Supreme Court did not agree with the petitioners, and they decided that if we cancel out every practice given or every extrajudicial customary practice, what is it what? In case both of them want divorce, that's a very good question. Just give me a second, I'll tell you right now. I usually write these words because I often forget. It's called Mubarak. Yes. That's a very good question, Himanshu. Everybody, if men and women both want to divorce each other, the practice is called Mubarak. Okay? Yeah. If a woman wants divorce, it is Khula. But yes. So Supreme Court dismissed the plea, and they actually were towards the inclination that if we ban this practice also, it will create a different agenda altogether. So it will create, yes, Mubarak, I just said. So if every practice, every customary practice that is given by Sharia is cancelled on a whim of a woman, that would present a bad picture towards a country which is already struggling to maintain a secular picture. Maybe that is the reason why they decided not to ban it altogether. It is not a whimsical or an arbitrary practice. Women have to take stand for themselves. If they surrender or they succumb to these threats, they're creating problems for themselves. So if they still want to stay with a man who is threatening them with divorce, that is their own discretion. They have a full liberty to end their marriages on their own and decide not to live with the same torturing villain of their lives. So that is something which is another thing altogether, another discussion. So let's not get into it. So a PIL was filed by journalist Benazir Hina through advocate on record Ashwini Kumar Dubey. The petitioner alleged that her husband has set her the first installment of Talaq through speed post on April 19, and the petitioner's counsel submitted that she received the second and third notices in the subsequent months. Now she argued that the practice is discriminatory since only men can exercise this right, women can't. But the Supreme Court, like I told you, said that women also can exercise the right in a different manner, in a different form, under a different name, but they have an equal right to dissolve the marriage. So it is not that the men only have the right to dissolve the marriage, women too have right under Islam to end the marriage. So it is not fair to label every practice as arbitrary and whimsical. Even you can exercise or take a decision to end the marriage. Okay. So that is the case, guys. I hope everyone is clear as to what we discussed. I would suggest you to follow us on Instagram, like us on Facebook, join our Telegram channel, and download our app from Google Play. Now you have to like the session, comment on it, share the session, and subscribe to our channel if you haven't already. And I shall see you again on Wednesday. Till then, everybody, take care. Thank you so much for being so amazing. Congratulations to everybody who got into the National University, Shivanya and Rishabh. I shall try to arrange for an interview with Shivanya so that you can talk with her directly, find out what miraculous things she did to get into the best law school in the country. Everybody, good night. Thank you so much. Yes, Sanjana, what is it? What is it? Okay, I'm waiting. Why did you not include Bilkis Bano? Because I just discussed Bilkis Bano yesterday. That is why I did not discuss it. Shubham, we have discussed Bilkis Bano case just yesterday. There was a very long session on it. What is your doubt exactly? No, I'm not on Telegram. The article schedule section. Articles are there in the constitution. So constitution is the law of the land. So whatever follows from the constitution, like every law has to be made in consonance with the constitution. So article is more like the origin point of everything that follows. So all the provisions in the constitution are called articles. All the provisions in the laws that follow the constitution or every law in the country are called sections. The law except the constitution is divided into sections. Schedules are basically the categories of administrative practices, like how will the governance and administration run in the country, what are the provisions, what is the process, that is given in the constitution in form of schedules. So those are schedules. Okay. How do you start for CLAT? Okay, so why don't you see the old question paper? The way to start with CLAT is to, you didn't attend, you can attend it, it's available. I took it yesterday. It is right there, Bilkis Banu. So the yesterday session, you can attend it, find out everything about Bilkis Banu. Okay, yeah. Okay, so Ashi, the thing is that, yeah, Himanshu is answering Sanjana's question. So I would suggest you download the previous year question papers of CLAT. Okay, find out and read the questions and understand the pattern in which the questions are asked. Then, after you are familiar with the pattern, I would suggest you watch the free sessions available on YouTube and BYJU'S portal. That would give you an idea of what the syllabus is. Start preparing along those lines. Try to solve sectional test. It is just reading a passage and solving a question. So how do you understand the passage, how do you solve a question, can come only through practice. You should be familiar with the syllabus, quants, logical. There are questions that are asked. If you're not familiar with those concepts, try to understand them through either a proper uh, you know program, a coaching program. BYJU'S can offer you many, or through your own preparatory material. You can do it through Google or anything. That's how you begin. So start understanding what questions come, how they come, and can you solve them or not. After you find yourself capable of solving the questions, start practicing as many questions as you can. That is what you would do, Ashi. Difference between constitution and IPC. Constitution is the law of the land. Okay, it is the law for the entire land. IPC is the Indian Penal Code that punishes for offences. Any crime that is committed is punished by the Indian Penal Code. That is the difference. There's a there's a whole lot of difference. Uh, yeah, there are two different laws basically. I'm not on Telegram. I'm not on Telegram, sadly. Okay, guys, thank you so much. Good night and take care.